So, hello and welcome everyone. Today we are going to take a look at a decision from Germany. It's a decision of the District Court of Munich, which was delivered in May last year. And it's a case between Atlas Global on the one hand, on the claimant side, and TP-Link on the defendant side. This was a case where the court examined several aspects that are relevant with the behavior of the parties when it comes to front negotiations. It looked at the notification of infringement, for example. It looked at the behavior of the implementer regarding willingness. And it looked also, to a certain extent, at the offer that the SEP owner makes and what is to be expected from the SEP owner. So a lot of different aspects covered here. And it's an interesting case to look at, definitely. We are going to go through some very basic background of this case here. Unfortunately, we're not able to have a full chronology of facts because relevant parts of the decision have been redacted. But generally, just to give you a feeling about how this dispute has evolved so far. Maybe very interesting here to notice that this is not a case which has been brought before German courts. There had been a parallel litigation, especially in the US. So this all started back in June 2021. There was the first time where Atlas Global sent a letter to TP-Link talking about its portfolio. We're talking here about Wi-Fi 6 relevant patents. So we're not talking about cellular standards here, but the Wi-Fi standard. And shortly after that, the first action was filed in the US before the US District Court for the Eastern District of Texas, where Atlas Global sought damages. Then the case was filed in Munich as well, and both of these proceedings were going on in parallel. In the US, we had a decision first. In September 2023, the jury awarded damages of approximately 37.5 million to Atlas Global. So Atlas Global won the case in the US. And the same was the case with the proceedings in Germany. So the Munich District Court in May 2024 also found in favor of Atlas Global. It granted, among other remedies, also an injunction against TP-Link. TP-Link appealed the case, and as far as we can see from public available sources, there has been no settlement yet. So these proceedings seem to be still active. So of course, there is a high possibility that we will have also a decision in the appeal instance here from Munich. And if this comes, of course, we will include this here and see if the views of the court will have changed in the second instance. Now, before doing that, let's take a look at this decision here. Here, of course, we had the finding of infringement, as we always do when there is an injunction granted by a court. So the court found that the patent in suit was infringed here. And what is for us more interesting is it also dismissed the front defense, which TP-Link had raised in these proceedings. As usually, the front defense was based on antitrust and competition law considerations here. So the argument, as it's usually the case in Germany, was about a potential abuse of market dominance. TP-Link basically arguing that by filing this lawsuit, which could end up in excluding TP-Link from the German market, Atlas Global had misused a market dominant position, so that the consequence of that should be that an injunction should not be granted. Now, the court worked on under this angle as well here. It examined first whether there is a market dominant position on the side of Atlas Global and confirmed that. It looked mostly on the technical aspects of things here by saying that if you look at the patent in suit, it's a patent that must necessarily be used when applying the Wi-Fi 6 standard. And the court did not see any indication in the proceedings that there is an equivalent technical alternative. So because there is no way from a technical perspective to not use the patent, the court found that there is a market dominant position on the side of Atlas Global here. But having said that, the court found that Atlas Global did not abuse the market dominant position. Looking at the negotiations, particularly, the court found that Atlas Global had made a license offer which was not evidently violating front principles. So, in a sense, it had done its part. Whereas the court was very clear to find that TP-Link did not do the same, and the court found that TP-Link had not been willing to take a license. So that was the main reason why the front defense was dismissed here. Now, the court started by looking at the notification of infringement. And this is just a quick reminder. This is a first step that needs to be taken before you bring an action before court, according to the Huawei versus ZTE ruling of the Court of Justice of the EU, which is basically the framework under which this case law, also in Germany, has been developed in the last years. So the question here was, has Atlas Global notified TP-Link sufficiently based on this case law? And the court found here that this was the case, so that there was a sufficient notification of infringement. The court said, in any case, a sufficient notification of infringement was given by the court action filed. And this is interesting because, as we have said, the notification of infringement should, in principle, be done before we have proceedings started. But here the court said even the court action filed itself would suffice for a notification of infringement, because we had a special case here where the claims that have been asserted by Atlas Global initially, so the lawsuit filed initially, did not include exclusionary claims. So it did not include a claim for injunctive relief or for the recall or destruction of infringing products from the market. Initially, the action filed included only claims for damages, information, and the rendering of accounts. So this meant that there was the action filed, the action itself included all the relevant information, and initially there was no risk, let's say, that there would be an exclusion from the market and potential abuse based on this exclusion from the market. So until these claims were then added to the proceedings at a later point in time, there was sufficient time to deal with that and to be aware of the relevant information. So that's why the court here found that although you usually would expect that the notification would be before the proceedings, and a sufficient notification was done here through the court action filed. Nevertheless, the court said, if you look also at the letters or the information provided before the trial, it was also sufficient, more or less, because the information provided would allow TP-Link to identify the patent and also informed about the specific act which constitutes infringement. And the court added here that you didn't require at that stage a detailed technical or legal explanation. So even if you wouldn't see in the action that was filed a sufficient notification of infringement, most likely the information provided anyhow before the trial started would have been sufficient as well. So this was the first step that the court examined here. And then the court turned to whether TP-Link had been acting as a willing licensee or not. And here the court found that it was not the case. TP-Link was not willing to take a license from Atlas Global. Again, we don't have all the details here of the behavior of TP-Link. So the court looked really at the behavior of the defendant from the beginning, from the receipt of the notification of infringement, and also the behavior during the trial. But again, most of these parts are redacted, but there are some points which the court highlighted, and I think are interesting to see how the court deals with willingness and what are, let's say, some key aspects or key points that the court thought were important here. For example, the court mentioned that TP-Link did not react to the first notification letter. This was seen as a sign of unwillingness. Then the court also noted that TP-Link searched for point of criticisms in every license offer that Atlas Global made, but not with an intention to, let's say, move things forward in the negotiations, but rather aiming at drawing a negative picture of Atlas Global. And apart from that, the court also turned to the counter offers that TP-Link made and looked whether you could basically extract some elements of willingness from that, or on the contrary, you could see also indications of unwillingness of how these counter offers were made, and especially when. So the court said, for example, that TP-Link waited too long to make a counter offer. We don't know exactly how much time it took, again, because the part is redacted in the case, in the decision, but it's clear that timing was important here for the court. So not only what type of a counteroffer was made in terms of content, but also when it was made was critical in the eyes of the court. And apart from timing, the court also criticized the fact that the counteroffers made initially were not for a global license, were on the contrary limited from a territorial point of view. So the first counteroffers were referring only to the US patents that Atlas Global holds. And in the eyes of the court, this is not sufficient. This was not sufficient to establish willingness here. On the counteroffer, there was also some more comments on the court here, maybe some principles that the court laid down, saying that when you look at the counteroffers and the terms that have been offered there, at some point in time, you would have needed TP-Link to be more active and, let's say, more substantially prepared to sign an agreement and to approach Atlas Global in a more active and substantial way, because they had been reluctant in the beginning in the negotiations, and time has passed in the moment after the parties have started to have contact. So here the court also said you should have expected more from TP-Link's side, not just to send an email, but to be more prepared to also reach an agreement actually now. And in this context, the court was not satisfied very much by the fact that some of the delays were, at least TP-Link tried to excuse the delays by saying that they were looking also at the parallel proceedings in the US, and they were waiting there to see what the court would determine, because they were under the impression that the courts in Texas is known for setting too high license fees. So the court said here, this is not an excuse. You should have been acting with more diligent and also more actively towards signing a license. Because at the end of the day, what the court criticized here is that without having a license, what TP-Link was doing basically is using the portfolio knowingly for free for a significant period of time. And this, in the eyes of the court, is not anything else than an example of a holdout strategy. So here, again, the counteroffer was very much in the focus of the court and how TP-Link behaved around the counteroffer that it had made. What the court also added here, and I think this is very interesting, is the fact that the counteroffers, after they had been made and that had been rejected by Atlas Global, were not followed by security payments on the side of TP-Link. Here, just a brief reminder, under the Huawei ZTE judgment, there is an obligation of the implementer who has received an offer and has made a counteroffer, if the counteroffer is rejected, to provide adequate security to the patent owner. And this is something that TP-Link suggested that it would do in the proceedings if its counteroffer would be rejected, but did actually not do at all. And the court saw that very critically here by saying that this indicated also delaying tactics on the side of TP-Link, because it didn't provide security for the counter offers that they had made, although they were rejected. And this is something that they should have done. And the court was a little bit more precise even by saying that at the latest, TP-Link should have provided security when the first counter offer was rejected, that included also Germany. So if you remember, we said already the first counter offers of TP-Links were just covering the US patents. At some point in time, the scope was extended, also covering Germany. And the court said at the latest, at that point in time, TP-Link should have provided security. The fact that they didn't do that was considered, again, a sign of unwillingness. Now, having said that, the court then turned to Atlas Global behavior. And here it is important to keep in mind how or what standard the court applied. So the court said here, if since we have concluded that TP-Link had not been willing, this means for Atlas Global that they had no further duty. So they had no duty at all to do anything else, and this included also no duty to make an offer. The fact that they did an offer here, however, gave the court some inspiration to basically look at that to a certain extent on for a specific reason here, because the court wanted to exclude that the offers made were totally unacceptable on the side of Atlas Global, because this would have an impact on how to assess the behavior of TP-Link. So if the offers were very, very bad, let's say, and were very much out of the front context, this could have an impact on what you would have expected TP-Link to do against these offers. And the court here looked at least to that extent here whether the offers were adequate as a basis of negotiations. And that was something that the court confirmed. So it's found that the offers that Atlas Global made eventually were not the perfect offers, but they were a suitable starting point for negotiations. So this was the only thing that the court examined here, again, because the implementer, TP-Link, was not willing in the present case, so a full assessment of front conformity of the offers was not required. Why were these offers considered to be a suitable starting point for negotiations? The main reason for that was that the court saw that the terms offered to TP-Link were in line with comparable agreements that Atlas Global had signed with third licensees. So here the court basically said, if you want to examine that, if you want to see whether the offers have been a decent basis to start negotiations with, it is sufficient to look at the licensing concept that the SEP owner has, and especially if this licensing concept has been accepted in the market through the signing of several licenses. Why? Because if the conditions that are offered to the implementer, which are similar to conditions with conditions that have been accepted by others in the market, then there is a factual presumption that the terms are reasonable. Meaning that if there are parties in the market that have negotiated and have found and have seen the portfolio, have attributed this value, the specific value to the portfolio, if you offer similar terms to that, then there is a presumption that these terms are reasonable. And in the eyes of the Munich Court, this was the case with the terms offered to TP-Link in the present case. There was some discussion of whether these terms offered to TP-Link would disadvantage TP-Link towards its competitors. That was the argument that TP-Link had raised. And here the court gave some input, was not very much convinced by that, by making clear that there is no need to offer exactly the same terms as those agreed with existing third licensees. So there are circumstances where there is, let's say, a leeway for the patent owner to offer a specific range of terms. You don't need to offer exactly the same terms to be front. And the court mentioned an example here. For example, if you have offered lump sum agreements to specific licensees, and you have offered also substantial discounts for lump sum agreements, this can make economic sense because the administrative burden is higher if you have a per running royalty, per device running royalty agreements compared to lump sum agreements. So Again, there is some leeway here, some flexibility to form the conditions, and not exactly the same identical terms for everyone are required. The same applies with respect to the question whether the terms were reasonable or unreasonable, as TP-Link had argued here. So the court said there could be unreasonable demands when you would compare a hypothetical price that would have been formed in a market would be a perfect competitive market. But again, you have to surpass a threshold here. If the terms are just different, this does not mean that the prices are unreasonable or the terms are unreasonable. This hypothetical price should have been exceeded to a substantial extent. So you have to go above a specific threshold in order to be able to say that the price offered is unreasonable. And there is a second element that needs to be also fulfilled here. You should have no economic justification for this differentiation on the terms. So here, these two elements were important to keep in mind. Again, the court saying that there is no need to offer the same rates to everyone. It can be problematic if you exceed a specific a threshold, which should be substantial, however, and it would be problematic if you have no reason for exceeding this specific threshold. So there are some conditions under which you can claim that the terms are unreasonable, and here TP-Link did not manage to bring that in the proceedings sufficiently. There was an argument that was raised that the specific portfolio here was the price for the specific portfolio was unreasonable because it was a Wi-Fi 6 portfolio, and it would lose in value when you have Wi-Fi 7, the next standard generation, spread into the market, or when you even have Wi-Fi 8 coming in the future. And the court was not convinced that this is a valid argument to argue against the specific terms regarding the specific standard that is there at the moment. And two reasons mainly for that. So the one is that its standard generation has a backwards compatibility, meaning that, of course, even if you use Wi-Fi 7 at some point in time or Wi-Fi 8 at some point, even later point in time, you will still be using patents that were relevant for Wi-Fi 6. And the court also saw no indication here that the future generations will evolve, let's say, totally independent from what is there today, ignoring the technical accomplishments of the current standard. So here, again, the court was not really convinced that this is an argument to say that the portfolio is overpriced because you will have future standards coming that is valid and can really offer here justification to say that the price for the specific portfolio is unreasonable. Then the final point here, which was interesting again, was some discussion about whether Atlas Global should have been treated differently, or whether the assessment of its behavior and specific of the offer that it had made should be based on a different standard, because Atlas Global is a non-practicing entity. So it's a company that has acquired patents, that has patents that the only purpose of its business is to monetize these patents. It's a non-practicing entity, and the question is, should you consider that when you look at the behavior that they had in the negotiations, and especially the offers that they had made? And the court was very clear here to say that this should not be the case. So the fact that Atlas Global is an NPE, a non-practicing entity, is irrelevant for the assessment of its behavior or of its offers. The NPEs and operating companies are subject to the same competition law requirements, more or less. So the court noted, on the one hand here, that there is in patent law no distinction between whether the patent owner who asserts the patent is the inventor of the patent of the underlying technology, or whether the patent was acquired for monetization. There is no differentiation in law. And apart from that, it went a step further to basically say that making monetize or splitting the development process from the monetization process when it comes to patents is plausible and beneficial. So here the court said the innovative forces are allowed to generate progress only when the need to monetize does not cause distractions. And the court also said that it is legitimate and worthy of support to delegate the monetization to specialized entities. So the court did not only say here that there is no basis in the law, in patent law, to distinguish between NPEs and operating companies, but it's rather positive or beneficial to do that and to have NPEs asserting patents which are not, or which are detached, let's say, from the invention creation and the patent development process. So I think that's an interesting view here, which the court shared in this context.